Hello, I am professional attorney and very much amateur musician Scott Lesowitz, and today I will be discussing and reacting to a Paul Davids video in which he complained and talked about how he's been getting these scam content ID claims on some of his videos, and they've been basically trying to steal revenue from him. So I'm going to react to part of that video and also try to provide some additional context. And I'll also talk about how Paul and other musicians can fight back against frivolous DMCA takedown notices, including ones where established musicians or record companies or music publishing rights owners submit claims that frankly are BS because the usage is clearly fair use. So I do handle quite a bit of copyright and internet law matters as part of my legal practice. But the reason that I feel compelled to make this video is that I'm one of the only people on the internet who's as good looking as Paul Davids and can react to one of his videos. All right, so in his video, Paul talked about how he had 3 videos about songs where he received content ID claims that clearly were not from people who actually owned any rights to the song. So here's a clip in which Paul discusses.
But this claim looked a bit fishy. It said I was infringing on the copyrights of the song Miserlou, spelled with an E instead of an I. And something even stranger, the song was called Miserlou feat. Tina Guo. And I don't think I know everything about Dick Dill, but I'm pretty sure he never recorded the song with cellist Tina Guo.
So if someone owns the right to music, so if the person who had uploaded the video wants to dispute the content ID claim, they can. Then whoever made the claim can either release the claim or reinstate the content ID claim. And then the video creators can either give up or appeal. So if the person who uploaded the video does this appeal, then essentially the content ID dispute process has ended. The person who made the content ID claim now either has to give up and, I guess in our case, go scam somebody else or maybe try their hand at scamming elderly people, or they have to submit a DMCA takedown notice. So this is where the copyright strike comes into play. Now you might be wondering here, hey, isn't this your first YouTube video? What the hell do you know about this? First of all, you might not know who I am, but your wife knows who I am. And second of all, my main YouTube channel is monetized. I have created this separate music-oriented channel because I found that the people who watch my main channel don't care about music. So here's a clip of Paul talking about the risks of escalating the content ID process.
If they don't accept your dispute, you either keep the claim intact and give a big chunk of your revenue away, you never know how much exactly, or you file a counterclaim. But now it gets really tricky because this time around, if they don't agree with you, you will get a YouTube copyright strike and your video will be removed.
All right, so a few things here. One is, it interests me why a scammer would ever issue a DMCA takedown notice. Presumably the goal of the scammers is to receive a share of the revenue from the video that they're targeting. Another thing that Paul doesn't talk about in the video that interests me even more is that if someone uploads a video and it receives a DMCA takedown notice and a copyright strike, can submit a counter notice under the DMCA. And under the DMCA, when Google receives a counter notice, Google is supposed to put the video back up online. And I also am interpreting Google's policies as being that the copyright strike is removed. Now at that point, the person or entity who made the original claim and takedown notice has to either give up or escalate to litigation and file a lawsuit. So I don't know what I'm missing here, perhaps, that people like Paul and also Rick Beato's had some videos about this, wouldn't go ahead and take the risk of getting the takedown notice. I don't know if they're too worried about the possibility of litigation. That's partly why I want to do this, is that I would not be afraid of that and maybe can help stand up to frivolousness. Or perhaps there's just something I'm missing. That's always possible. Just ask my wife. It's possible that I'm just wrong. But In regards to frivolous takedown notices under the DMCA generally, there is a weapon that can be utilized, at least in theory, against people who make frivolous claims. And this would work especially well if it's someone with a lot of money who's easy to locate, such as a large record company or music publishing rights owner. And that is that under 17 USC section 512F, someone who is a victim to a frivolous takedown notice, and that can include one that was frivolous because it was obviously fair use. It can also be one that's frivolous because the person doesn't own the rights to the songs and is a scammer. The victim can sue, and if they win, they can receive their reasonable attorney's fees. Now, this obviously wouldn't work as well with a scammer who might not have collectible assets, might be hard to locate, etc. So I have some nifty ideas for that. That's partly why I got interested in doing this whole YouTube thing. And so hopefully you can join me for this ride. See how it goes.